The High Court fell in grave error in holding that the suit was barred by time and ignored to appreciate that the right of the applicants to have the revenue record corrected arose when the applicants came to know about the wrong entry and the respondents failed to join the applicants in getting it corrected. The High Court was not justified in holding that mere existence of a wrong entry in the revenue records does not in law give rise to a cause of action within the meaning of Article 58 of the Schedule of the Act. The impunged judgment of the High Court on the question that the suit was barred by limitation cannot be sustained. Therefore, the judgment of the High Court is set aside and the matter remitted back to it for decision on merits expeditiously. Next appeal is directed against the final judgment and order of a learned judge of the Punjab and Haryana High Court dismissing a second appeal being regular second appeal number 22 of 1995 inter alia on the ground that the suit for declaration and injunction filed on 21st of August 1988 was barred. The plaintiff and the applicants were the owners and in joint possession of share in the entire land measuring about 280 canals and 8 marshals of Khewat number 21, Khatauni number 84 situated in village Ramnagar under Panchkula. The applicants and the two individuals were co-owners in the said total land. Since the applicants and the two individuals were co-owners in the said land, the said share of the land was already under mortgage with the respondents. In 1965, the respondents got their names mutated in the relevant record of rights as owners of the area purchased by them as indicated in the aforesaid sale deed. The applicants filed a pre-injunction suit being pre-injunction suit number 37 of 1960 in the court of the subordinate judge class 2nd Panchkula against the respondents for possession of 2/3 share sold to them and got it decreed in their favor by the trial court by a judgment and decree dated 30th of November 1967. The respondents appealed against the aforesaid decision before the appellate court, namely District Judge Panchkula, who dismissed their appeal. Feeling aggrieved against the judgments of the courts, a second appeal was filed. Subsequent to the dismissal of the second appeal, the applicants and the respondents compromised their dispute and such compromise was reduced into writing. According to the written compromise, the applicants were entitled to retain half of the 2/3 share of the land in dispute and the respondents were to retain the other half. The respondents admitted in their compromise deed that the applicants had taken possession of their share of land. When this compromise was presented before the division bench of the High Court of Punjab and Haryana in letters patent appeal which came to be registered, the division bench of the High Court disposed of the said letters patent appeal in terms of the said compromise petition. Leaving aside the other facts in the present case, we may state here that a specific defense taken by the Respondents in their written statement was to the effect that the suit was barred by limitation in view of Article 58 of the Act because the suit having been filed after about 18 years of entering into the compromise by the parties in the High Court in the latter's patent appeal must be filed within 3 years from the date of entering into the alleged compromise by the parties. According, the respondents alleged that the suit must be dismissed on the ground of limitation. We make it clear that since the only question involved in this appeal is relating to the question of limitation, we have not considered the other aspects of the matter in this judgment. After the parties had entered appearance and led evidence in support of their respective cases also on the point of limitation, the trial court held inter alia that the suit was barred by limitation in view of Article 58 of the Act as the cause of action arose in 1972. The High Court has not exercised the caution that was expected to while dealing with the judgment of acquittal by the trial court. High Court was not justified in interfering with the well-considered judgment of the trial court. The judgment of the High Court is set aside and that of the trial court is restored. The appellant is allowed to go in appeal to the higher court if he is not satisfied with the judgment of this court. Leave is granted to pursue the matter in any court for final decision.